Welcome to the Eating at a Meeting podcast. I'm your host, Tracy Stuckrath, dietary needs expert, certified meetings manager, certified food protection manager. I have searched the globe to find people and businesses who are creating safe, sustainable, and inclusive food and beverage experiences for their employees, guests, and communities. In each episode, you will find authentic conversations about how food and beverage impacts inclusion, sustainability, culture, community, health, and wellness. I know that sounds like a lot, but we're going to cover it all. Are you ready to feed engagement, nourish inclusion, and bolster your bottom line? If so, let's go.
Hi, everybody, and welcome to another episode of Eating at a Meeting. I am your host, Tracy Stuckrath, and today with me is Josh Grimes. He is a leading meetings and events attorney based in Philadelphia. He's a noted speaker on legal issues relating to meetings and conventions. Hi, Josh. How are you?
Hello. Hi, Tracy. Good afternoon or good morning, everybody who's watching.
Yeah, and welcome, everybody. I know we got a lot of pickup on our LinkedIn posts as well as on Facebook group. So I'm excited to hopefully see a bunch of people on here commenting. And I wanted to say that I think I first saw you speak when we were in Philly, both speaking together, and you were talking about the guns in buildings.
Yes,
right?
That's very possible. Back in the good old days when we weren't talking about COVID or other things, we're talking about guns, right?
Right, which is still a topic of conversation.
Yes, it is.
Yes. So welcome. And today, though, we are going to talk about food and beverage in 2023, how to contract that. And there's a lot of hotel contracts are long enough. And then there's always this section of the contract it's specific to about food and beverage. Well, actually, there's a bunch of different sections in contracts that talk about food and beverage. So, the first thing is how can meeting planners be prepared and protect themselves in contracts going into 2023?
Well, now more than ever, the key is to put everything in writing. Whatever assurances, what kind of food you're going to have, the prices, the other charges, the quality of the food, deadlines for submitting, all needs to be in writing. And you mentioned the length of the contract earlier in your comments, and that's true, but it's really what's in the contract, not how long it is, that matters. Days of the handshake meeting contract are way over. And one of the things we've learned since COVID is that now it's even more important to button down our contracts because there's some sense of venues and caterers and hotels having more of a need to recapture lost revenue. And then most people planning the meetings also have fixed costs. So I've got a list of about 10 different F&B related clauses that I put in contracts, but everybody needs to do what's important for them to make sure they're covered.
Well, and I have a bunch of clauses that I sent to you as well that clients have used and that I suggest that relate to food safety. All right, let's just talk about, I'm going to bring attrition up first. Let's talk about attrition. Food and beverage attrition. What can we do now because there's a lot of properties that are saying they're getting their RSVPs a week out, right? Or their numbers, the event planners, their numbers are skyrocketing like really closely, whereas properties are having to secure their food and beverage more than a week out, more than 72 hours in advance. What can we do about that?
Well, right. Food and beverage attrition has always been, and what matters there is whether you meet their minimum commitment. And the logic there isn't so much on cancellation when they purchase the food is more of a relevant factor. And also when they schedule their banquet staff and that sort of, but really the key with attrition, with food and beverage attrition, is a lot of venues will say, well, we only reserved the space for your group because we thought we're going to make a certain amount of money. So if we don't make that money because you're buying our food, then you need to make up the difference. What I see keys on that, and the first one's always been a key, is how much of the shortfall, if you don't meet your minimum, should you be paying? In industry, it's thought of as the lost profits percentage, which is really what makes the caterer or venue whole, should be about 40% of the cost of their food and beverage because they're not buying the food if you don't need it. But the other thing, which is the new wrinkle that I'm seeing, is sometimes charging a service charge on the attrition amount, on the shortfall. So maybe the property charges 70%, maybe they charge 100% of the difference between your commitment and what you actually made. But then see, some properties want to charge a 26% service charge on top of that. And it's whatever you agreed to in the contract. I think it's overreach because there is no service provided. Frankly, in some cases, it's kind of a fiction that it's for service in any event, as opposed to just an additional cost capture. So that's another thing to look at that's new with food and beverage attrition.
And especially if you don't catch that up front, right? If you don't see that in the contract and they're like going to charge that to you after the fact, if it's not spelled out, that's really something to catch up front.
Right. That's true. And look, the challenge with contracts, and this is how I make a living, so maybe I'm a little prejudiced on this, but contracts there are things that are in contracts, and then there are parts of contracts that are really kind of hidden, the meaning on them. And I'll give you another example off the top of my head. Sometimes we see a contract will have a minimum, but then it will say, if you add additional food and beverage events to your meeting or your event, we're going to increase your minimum commitment by the amount of those additional events. Well, since you booked the meeting based on the original minimum, why should, if you agree to another F&B event, if at the same meeting, why should your minimum increase? It's another reason that if you have to cancel, or it's a higher bar to meet to not pay attrition. And that's something that's not obvious, but you need to watch for it, because I see it more and more these days.
And that's something that somebody who's not seasoned in looking at a contract will not see and understand.
That's right. That's right.
And that's something that, and the way that contracts are worded, sometimes you don't understand what that means. And it's really important to get those statements clear on what that means.
Yes. So I should have said at the beginning of this, when I said, make sure you have everything in writing, you need to also make sure you understand it, that what you're getting into. And that's for two reasons. One, because meaning venue, caterer, the planner needs to be on the same page and understand what the terms are. But the other thing is that in the event you have a dispute and it has to go to arbitration, mediation, court, you want to make sure that judge or arbitrator or mediator also understands what the obligations are. And if you don't understand it, chances are someone else isn't going to understand it. Right,
exactly. And it's really valuable. I mean, I never thought about making sure the arbitrator understood it too, and if you're a seasoned event planner that knows how to read a contract, you kind of get some of those terminologies. But again, if you're not seasoned, and we have a lot of people coming in from the hotel side as well as the planner side that might not understand what those contracts clauses mean.
Yeah, you'd be surprised. You'd be surprised at what I see. I don't put bad intent on anyone. I just think that sometimes we use the same contract time and time again. In fact, I frequently see contracts where there's little mistakes in them, like cut off sentence because somebody cut and pasted and forgot to do the whole sentence. And who knows how long it's been that way, right? In the property's form contract. It's just what it is. So you got to read them.
Exactly. All right. So Tornona Arkansas is piped in here, wants to cover the policies mentioned by word but not attached and often apply to food and beverage. How do you encourage venues to spell out and include? And I'm going to add something to that in the fact that I did an event a couple of pre-COVID, and it says, we'll refer to the 25-page meeting planner document to see what that standard is. So it's like, please, the addendum, there's another 25-page addendum of the meeting planner contract that has one line in it about, you're only allowed to do this, right?
Right.
That needs to be spelled out in the contract.
Yeah. So the reason I'm smiling at this is because you're talking to the one guy who follows those links and reads them, because that's what I'm paid to do. So yes, frequently. And in fact, right now I'm dealing with a situation where someone's asked to sign a convention center contract, and the convention center has an exclusive caterer, which I'm concerned because my client doesn't have the catering contract yet. But I followed the link to the caterer and looked at their menus, which have 5 pages of terms and conditions attached to the menu, which I think will likely end up in the contract, what they eventually get from the caterer. But I said to my client, how can you obligate yourself to go to the to the convention center before you have a deal with their exclusive caterer? I mean, what if the caterer triples the price of the menu items? And then you're stuck because you've already signed a convention center contract. So, I mean, I can only advise my clients, but the point is that I read those things, and it's incumbent upon you. Now, if you didn't read it, are you absolutely stuck? Depends on the situation. I mean, I suppose if there's a big enough dispute that you could try and argue to a judge or a mediator that you never read it and they didn't put those terms in front of you, but you can't count on that. And frankly, very few disputes in this industry ever go to a judge or a mediator. It's really leverage to solve it, but there's really nothing. And by the way, the other point I will say on this is that if someone says you agree to the terms and conditions at this link, you should be agreeing to the terms and conditions that as exist the day you sign that contract. Because if it says, and they frequently do, as these terms may be amended, well, what if the caterer's terms are amended to say that you have to pay a 90% service charge? I mean, you could say Josh is being a little extreme, and I am, but I'm illustrating a point. You contain your costs. How do you know what you're involved with if you agree to terms and conditions that could be changed tomorrow?
Or just thinking about the convention center side, or even a hotel. I mean, what if that convention center severs ties with XYZ caterer and brings in a different food service company to do it, and their terms and conditions are different? So that I totally agree with you that those two contracts need to be melded, and it's probably not really thought about sometimes, because when you go to a hotel, you've got everything's in one in all encompassing, whereas a convention center or an outside venue, those things are different.
That's exactly right. And it would say, unfortunately, once burned, people learn this lesson. Again, it's what I do, so I look at these things, but I wish the average planner would take the time to read all of the terms, but I don't guess that they do. And so people sometimes get caught. That's why the caterers and hotels write them this way.
Well, and I think too, it's when they maybe send it to their attorney who's not necessarily a hospitality attorney, some of those distinctions are not caught by corporate attorneys, right? Because they don't understand the industry.
That's exactly right. And it's people's choices which attorneys to use and all that sort of thing. But yes, that's right. And I would say that a decent portion of my business is after something goes wrong and I get a call from an in-house attorney or the regular corporate attorney saying, we're looking for someone who knows what they're doing with this because we've gotten stuck. How do you get us out of it?
Oh, wow. Okay. And Joan just is commenting here, once burned can be a nightmare. Totally agree. I mean, because you don't necessarily know where you're going to be after the fact.
That's right.
So so in a contract that I was working with last year, the hotel was really adamant about you need to have, and a lot of contracts are this way, you have to have your food and beverage minimums or your menus designed 45 days out, 60 days out. And if you don't have your menus done by here, then you're going to get 40% added on to your bill or whatever it is. But I've also heard on the backside of that is that planners are not getting their banquet event orders until they're getting on the airplane or 4 days before the event. And we've been legally bound to say, hey, we've got to give you these by 45 days, but you're then waiting another 42 days to give us back the information. How do planners manage that?
Well, it's a matter of negotiation. Okay. You're right that these days that commitments are being made much closer in than before because of the uncertainty in the economy and people are still getting back to meeting and all that. So if you're signing a contract today and you know that there's a problem with those deadlines, you need to renegotiate the deadlines. And I find frequently they can be renegotiated, but better to negotiate it before you sign the contract when you have more bargaining power. The other thing is that maybe you can agree with the property, and usually it's in the contracts, that you'll give them a minimum and then you can add to it after the final numbers are in. It's just going to cost you a surcharge to add it later. So if you see the numbers trending a certain way, you agree to a certain level and then add something for the later added attendees. I would suspect if you tell your clients you're going to be in this position, hopefully your clients work with you to get the numbers in earlier, or at least they understand they're going to have to pay more for numbers added on after the 45-day date or whatever date you agree.
Well, and how can I explain or claim the hotel responsible for getting back their paperwork to me in a timely fashion?
Well, I guess that you have to agree on deadlines. Other than that, there's probably not much you can do about it. Because what are you going to do if they don't give you menu prices by the date they promised, or they don't confirm a BEO or give you a BEO by the date they say they will? I mean, what are you going to do? Cancel the meeting? Probably not. You just have to. That's one of those areas that if you're persistent, hopefully they get it to you and you build in a few extra days that will work on your end, so you're not on a tight deadline.
Right. And I think one of the biggest challenges on the property side is that some of those changes don't necessarily get made all the way through their food, quote unquote, food chain. We're talking about food and beverage, food chain through the rest of the property too. So it's really pushing that and making sure those deadlines are met.
Yeah. Although, you know what, I don't mean to be cynical, but I've been hearing for 2 years now, and probably you have and everybody else have. Well, we've got staffing shortages. We've got this, we've got that. Yeah, they do have staffing shortages, and I'm somewhat sympathetic, but has the price of the catering gone down? Has the price of that they're charging in the room gone down? No, it's gone up. And you have the right to expect a certain level of service, and you have the right to expect that the hotel or the caterer will pay people enough to sufficiently staff the pre-event logistics and the event once it happens.
So how do we protect ourselves for that?
Putting the appropriate clauses in the contract. Okay. Pretty much every caterer I ever deal with, every venue, every hotel has a flashy web page where they talk about how they provide exemplary service. And frankly, most of them do. I'm not trying to be cynical. I mean, they do, but they advertise a certain quality of service, which is what probably attracted you to go to their venue in the first place. You have the right to expect that level of service. So how do you put that? You can have a service clause in your contract that says the hotel's website represents that it will provide this kind of service. Hotel agrees that its service will be consistent with the description on the website. I'm kind of paraphrasing, but that's the kind of thing. If your group has particular needs, so for instance, you know that your attendees are heavy drinkers and they're not the types that want to wait in the bar, maybe you want to pay for a few extra bartenders. Maybe you want to pay for some extra servers. And that should be in the contract. If you have if you need more than what's customary, you may have to pay extra for it, or maybe it's part of your grand bargain to have the event at that venue, but that should be in the contract. If you're having a certain number, and some planners know exactly how many they need for the number of people. If you don't have specific numbers, you're allowing the hotel to choose, which isn't a bad decision sometimes, but they're going to do based on their experience what the average group would want.
Well, and typically a bartender is 1 per 100, sometimes 1 to 150. And like you said, if you're heavy drinkers or you've got to figure that out. And as a planner, you need to understand how many bars actually will filter through, how many of your attendees will filter through that bar, and the skill set of those bartenders too. That makes a big difference.
Yes. And of course, this is off topic a little, but all the bartenders should be trained and have the whatever experience required by law in the state or country you're meeting in, so that they can recognize when someone shouldn't be served, either because they're underage, however that's determined in the state you're in, or otherwise intoxicated and shouldn't be served. So that's important for bartenders too.
Oh, and well, I've had one of my former coworkers get overserved and fall in a fountain. So where's that blame? And when you have multiple bartenders, if she was visiting multiple bars in that event, they should be aware, they should be cognizant of that. All right, we've got a question again from Joan here. convention centers many municipally owned and or managed are now saying they will not make any changes. Are there any arguments to explain to them why it's favorable for all parties? And she added to that saying, in fact, they won't send a version of the contract that we ask any questions, just accept it or not.
Yes, Joan is absolutely correct in it, but she said many, not all. Look, municipally owned convention centers are a challenge because they are not necessarily goal oriented. They are seen as profits are important, but they're seen as loss leaders sometimes for the surrounding city's economy or for the hotels and the other parts of the hospitality industry that will benefit from a meeting. And frequently their lawyers don't have the patience to deal with contract changes. And at the same time, sometimes they're boxed in, meaning that the laws of a particular city will say, for instance, that the facility cannot indemnify. And I find that all the time. They will limit, and I'm dealing with this in a certain city right before we came onto this today. The group needs to fully indemnify the city from basically anything, except if the city is solely grossly negligent. But the city refuses to do any indemnification of the meeting group. So how do you deal with it? What I suggest is you can't negotiate, and then you can negotiate, but we're not going to make it easy. And what I find is that for smaller meetings, you probably can't negotiate. For most meetings, I recommend to clients, let's take if there are 4 or 5 critical issues for us, let's take those 4 or 5 back and see what happens. Don't take 30 issues back. Take your keys. Having said that, there are some people, and maybe some listening here, who represent some organizations that are such great pieces of business, either because of the revenue they bring to a city or they have some political sway or whatever, that they'll get whatever they want, even though the convention center won't negotiate any other contracts. And I've had experience, in fact, frankly, I love those because they make me look good when I get all the changes. But those exist as well. To boil it down, what I would advise is first, don't sign your hotel contracts until you have a convention center contract, because otherwise you're bound, you have no leverage. Or sign your hotel contracts and put a convention center out, as I call it, in there that says that if we can't reach an agreement with the convention center, we can cancel all the hotel contracts without liability. And then try to hold sway, limit it to a certain level, few numbers of issues, as few as possible, but don't obligate yourself to go to that city until this contract is done, because otherwise you have no leverage. So I'm totally sympathetic with Joan and others on this point. It is not easy, but you have to use your leverage and narrow down the number of issues, and sometimes you can have some progress.
Well, that's a really good point. And I like making sure that you've got it all in line, especially since people are like, hey, we're going to go to XYZ city next year and you don't have any contract signed, right? Don't go marketing yourself for that to get it, because then you're going to get pushback from your attendees as well. So a Facebook user in here, I think it is CT McAllister, is saying that I'm seeing so many e-sign contracts initially now, post-pandemic, which is so frustrating.
Yeah. I mean, look, you know what I do? I find the free app on the internet that lets you convert PDF documents to Word documents, and I don't hesitate, make them Word, and if I need to mark things up, I mark things up. The e-sign thing is leverage. It's to discourage you from making changes, but look, until you sign on the dotted line, there's no contract.
Well, and I've had an unsigned contract from somebody, and I sent it to you. I'm like, need you to review this because there's things that I don't agree with in here, and I never heard back from them. So,
is that right?
Yeah, never heard back from them.
Yeah, I mean, look, some vendors will just not negotiate things. That's what it is. Period. And some can't because they're franchises of a larger company, and all that boilerplate language was given to them, and frankly, they don't understand it either. But That's not every circumstance. Look, everybody's in business, right? And it's better to discuss the few issues you have, at least in my opinion, than to lose the business. And unfortunately, sometimes you need to convince them they're going to lose the business if they don't negotiate with you. But if you have to do that, you have to do that. Where this isn't, we can be wistful about 10 years ago, even when there were relationships in this business and you could have a talk person to person over anything and work it out. Unfortunately, that's kind of disappearing. So you have to play more hardball these days, if you hardball is what you want to call it.
I totally agree. And stick to your guns. So, okay, I want to jump to contracts that were negotiated in 2019 or January 2020 that are now being pushed to 2023 and beyond. And a lot of times we're always putting in the clause that saying, hey, the cost of food is only going to be a certain amount, or it's going to be based on the previous year's food and beverage menus. What are you seeing with that right now? And what can planners, because the price of eggs alone right now is astronomical, and that goes into your pastries, that goes into your breakfast meals, that goes into a variety of other things. How can planners work with properties, not make them stick to a food and beverage costs from 5 years ago when it was negotiated to these prices, but still maintain some budget?
So here's where I'm not the most aggressive lawyer, because I spend all day dealing in this industry. I get it. We all know, because we go to the supermarket, prices have gone up. I get it. If I were a difficult lawyer, which I can be, I would say, well, hotel, you signed a contract. If you had signed a contract with a group obligating the group to pay $400 a night for a room, and in the time between then and now when the meeting's held, room rates go down, is the hotel going to let the group pay much less? Sometimes they will, but they don't have an obligation. But that's the hardball part of this. The answer is that prices have gone up, and I think it is appropriate for planners to listen to what hotel has to say and consider, as a goodwill gesture, whether you have the obligation or not, paying more. There's two reasons to do that. One, because the hotels have extra costs or the caterers have extra costs. But the other reason is because they might look for other ways to cut back on your meal if you don't, while remaining in literal compliance with their obligation. Portion size may go down. They might substitute cheaper ingredients, that sort of thing. So it's best to talk. That having been said, though, if I were signing a contract today, I would be concerned about the price increase clauses. Many hotels and caterers will agree that they won't raise prices more than 3% a year, 5% a year between the time you sign the contract and the time of your meeting. That's worth looking into to protect everybody. But even then, you need to be careful how you phrase that. I had a group that signed a contract in 2019 for a meeting this year, and the hotel raised prices about 40% on the F&B. And the group said, but we have a clause that says no more than 3%. And the hotel's response was, but that was from prices from the prior year in 2022, not prices from when you signed the contract. The 3% isn't from when you signed the contract in 2019. And I don't agree with the hotel's position, but this was the dispute, and we had to figure a way around it. So it's important to be very clear. The other thing is to be careful, and this is a different issue but related, about service charges. Many contracts will say group pays taxes, applicable taxes, and service charge at the time of the meeting. And then it'll say, like, our current service charge is 26%. Well, if it says you're going to pay the service charge at the time of the meeting, how much are you agreeing to pay? 26, 28, 40? You need to say, agree, this is the service charge, and that's it. The other point I'm seeing recently, and forgive me if I'm moving on to more than you asked me about, is I'm now seeing sometimes venues charge service charge not only on the F&B, but also on the meeting space rental, paid service charge on both. And I'm also seeing service charge tacked on to attrition and cancellation damages, even though there was no service provided. So this is all, I'm coming off that hotels and all are sort of evil in this. I don't mean that in any way. I think they are changing the equation to increase their revenue, and it's incumbent upon planners to notice those things and ask the right questions and object where appropriate.
Exactly. And I think that's a good thing to say, is that it is a compromise, right? We should be in this to win-win, and it shouldn't be a one-sided or the other-sided. It is here so that we can bring the business to your city, to your property, to your employees, so that they have something to do. And I know, and I'm going to get to this comment that's in here, but I remember going to an event in Vegas, and the servers that I was talking to are like thanking us for being there. Thank you for bringing us to work. So we're not here to steal all your money, properties, right? We want to make it a win-win for everybody. So this is going back to your 3 to 5% thing, is this Facebook user, and I think it's CT McAllister as well, is 3% per year. So I think I missed something. So in 4 years, so that's now 20% max?
Well, yes, that would be if you did it that way from a 2019 contract, maybe if that's 5 years. I forget the specific language of the contract I was talking about, but I think what it said was that the hotel agrees not to raise prices more than 3% from the prior year, and which seeing a lot of these contracts, I understood to mean, and my client understood to mean 3% a year. But the hotel said, no, we start with the menu prices in the prior year, which of course, in this case, the hotel chose the December of the prior year, not January, because of inflation. Prices in December were much higher, and said, we start with those and then we won't raise it more than 3% from those prices. So it was much higher. In any event, this is where I say, I've been doing this a long time, but I learned something every week. Now I know I wasn't involved in the negotiation of this contract I'm talking about, but now I know to look out for that language and make sure it's buttoned down. And my client understands exactly what the 3% increase a year means when it starts.
Well, and it reminds me of when you're buying out a restaurant, right? They're going to charge you the buyout rate of what it was. Typically, it was the exact same date the year before. Yes. So I would say that the prices should be kind of thinking in terminology that way, the same prices as January of last year, December, a month before. Right.
That's something you could assume, but if it's not in the contract, it's the subject of potential debate, right?
Right. Exactly. I want to jump back to something that Lynn Wellish put in here. I just learned that there's not a charge for a bar back, but there is a charge for bartenders, which typically, Lynn, I've seen the charges for the bartenders, and she also said, do we have to ask if there's a fee for cocktail servers? I would definitely ask that, but I think going back to what you said at the very beginning is, what is your service level? How many staff do you typically provide for a group this size?
Right. And so you enumerate, if you need to, hotel providing, bartenders, banquet staff, bar backs, whatever they're providing. And you can have a general clause in your contract that says there will be no additional charges other than those we've agreed to without the group's prior written consent. And so if they're sending you a bill later that says they're charging you extra for other banquet personnel you didn't agree to pay for as part of your event, you can contest that. Now, be careful on that, though. Sometimes a BEO will include extra charges, and I would say that's wrong. They shouldn't have additional charges unless it's prominently brought to you that these are outside of the contract you signed and you're okay with it. But I've seen that where they say that the BEO had additional personnel or had extra food costs and you signed the BEO, so you agreed to pay.
Well, and that point to bring up, because the BEO is another contract.
It should be, because you have a meeting contract. And the BEO is not the place to, if you want to amend the meeting contract, then you should amend the meeting contract, not give someone a BEO a few days before the event and say, hey, we've got this new charge. But
that's
you need to be careful on these points. It's kind of hard to deal with some of this when you sign the contract, because you hope they wouldn't put something in front of you didn't agree to.
But that just reiterates the importance of looking at your BEOs very carefully as well because of that situation right there. And they say if it's not on the BEO, it doesn't happen. But if it's on the BEO, it happens. But again, if those BEOs are being changed 72 hours in advance, is that information getting seen? Because most BEOs are not redlined. They're just changed in the system and you can't see them.
Well, if you haven't seen it, then you're not agreeing to it. But look, a BEO is a banquet event order. It's not a contract amendment. And I feel confident that if it's intended to amend the contract, it should state that pretty clearly on it, not sneak it in.
Oh, I love that. Thank you. That's a good tip. Yeah. I mean, but they do make it sound like that as well. And you are agreeing to, this is your numbers and in a way it is, you're agreeing to what you're guaranteeing on that. So that is what they're going to base their charges on. So, yeah.
But that's different. You've already agreed at time of contracting that you're going to come up with a number of attendees for the event function, and it's going to be in a BEO. That we know. I'm not suggesting there's anything inappropriate about that. I'm saying that to add a 30% service charge that wasn't in the original contract in the BEO and say, oh, we've raised our service charge. If you didn't agree to a higher level of service charge, it shouldn't be made part of the contract through the BEO, unless, of course, it's acceptable to you.
Right.
Then it's okay.
Yeah. I don't agree to a 6% raise in service fee. Right. Okay. So some of the things that I talk about as it relates to food safety, I want to know, and especially coming out of COVID, everybody was very concerned about food safety standards, how you're managing this. What I teach is that ask how many people have their Serve Safe certification, how do they have allergen training, and things like that. Putting that into the contract as well so that we understand the level of service that they have in that. How do you feel about those?
Sure. If it's important to you, I mean, I think that a lot of planners imply or sort of figure, well, I'm dealing with a very reputable hotel. Of course, they're going to have Safe Serve certification and whatever else they need. And I would like to think that you can rely on that. Look, we all go to restaurants and you don't necessarily see the health inspection certificates of each, unless you're in a city that displays them. You just take it as a given. But if it's a particular importance to you, you should put it in the contract and then follow up by looking. Most cities and have health records available online. You can see the inspection reports. And if there's a red flag, you bring it to the hotel's attention or the venue's attention before the meeting. This is a challenging one because they can say that people are certified in one way or another, and the law will frequently require it where they are. But what if that person's off that day? It's a tough one because I'm not sure what the remedy is if they don't follow what they're supposed to do. So that's a reason to go with reputable venues and caterers, because hopefully this issue doesn't arise.
Yeah. And actually, back in 2020, I asked the group, like, how many of you have, and I've asked it since, how many of you asked about the health inspection score of your property before you contracted it? And 71% said never.
So, that would shock me.
No, it doesn't shock. It does and it doesn't. But I think it's really important. And I do think it's important too so actually another clause that I want to talk about, which I don't think I gave to you in advance, so I'm just throwing this out at you. But understanding food allergies, diet, disability, other disabilities. Food allergy eating was added to the Americans with Disabilities Act in 2008, which gives civil rights protections. So how do we address food allergy management and diabetes and celiac disease, the culinary team under the auspices of the ADA?
Well, this is an important issue. And if I might go to a marketing, and I'm doing a presentation with the Greater Philadelphia PCMA chapter on February 2nd about accessibility issues with a panel. And this is going to be one of the things we're talking about. The answer is the law requires certain things, but planners should go above and beyond to make sure that it will be taken care of. So you can include a clause, and frankly, I included standard these days about special meals. It may not be right to call them special meals, but that's what we call them in the clause. And we say that the hotel agrees to prepare special meals as required, provided that they're notified appropriately in advance. And special is everything from gluten-free, vegan, nut-free, kosher, halal, all those sorts of things. But the other important thing is that we ask the hotel to agree, or the caterer to agree, not to inflate the price of those special meals beyond the actual extra cost that it charges in the property's own mid-level restaurant for that item over the cost of a standard meal. So, because these special meal prices are frequently way inflated, and that's inappropriate. Oh, we ask them to agree to a reasonable surcharge, which would be approximately what they charge in their regular outlets. And then, as you say, you can agree that the property that you're going to tell them 2 weeks in advance if you need gluten-free, vegan, kosher, whatever, vegetarian, however many you need. But of course, the ADA requires reasonable accommodation. So even if you only find out 3 days in advance, if you tell the hotel 3 days in advance, unless it's unreasonable for them to deal with that special meal, then they still have that obligation.
You need to turn the entire event vegan or...
Well, reasonable is not a defined term because it means things to different people. So for instance, if I'm a small catering operation that deals in specialty foods where the ingredients need to be ordered 3 weeks in advance, whatever those foods would be, it might be unreasonable for me to cater to a vegan person 3 days in advance. However, if you're a major hotel that makes, or cruise ship, or airline, or whoever that makes tens of thousands of meals a day, what's reasonable is very different.
Yeah, very true. And it also goes along the lines of, hey, with the supply chain going on right now, what can you get and what can you get? And so, and if you're doing an event way off property, it's unreasonable to assume that I can just walk to Whole Foods or the grocery store and buy something if I need it, right? To meet that need.
Well, it depends. It's interesting because one of the things that, and again, this is where I remind you're talking to the lawyer. I'm not involved in the day-to-day logistics of F&amp. Maybe that's apparent to a lot of you who've been listening and watching this now, but I've never understood why a caterer or venue will say, well, we're out of the low sodium ketchup that someone has a low sodium diet needs. When, to me, why can't they just walk over to the supermarket and buy it? But they do all their purchasing from Sodexo, so they need to order it from Sodexo. But this is a different conversation. I guess I'm a little less understanding, but it depends on the circumstance. If it's a caviar type they need, if it's a food that's not found commonly, then yeah, it may not be easy for them to get it.
Well, funny that you couldn't say that. I was talking to a chef yesterday and he's in Canada, but he was saying, he's like, oh, we need this. And he's like, all right, well, I'm going to go to the grocery store. And one of his sous chefs or something, like, you're really going to go to the grocery store and get it? He's like, yeah, because we need it. So I'm going to go. But that's the level of management, and understanding that is really important before you sign that contract. Yeah.
And again, it also goes to the confidence of the caterer or hotel you're entering into a deal with. If it's a higher quality, higher reputation, a 4 or 5 diamond hotel, my expectations are different than if I'm dealing with a lesser property.
All right. So we've got Wolfgang is posting on here. We also need to be more diligent in asking for copies of the actual Banco checks following the event before we depart the hotel, including verbiage so it's documented. 100% agree, because you're waiting and accounting is behind or the CSM is behind, making sure that you get those checks before you leave so that nothing is added in there later on.
Right. Or, yes, then that's a good point. Or don't agree that you're going to pay the remaining 100% of the remaining balance on your credit card right the second the event ends. I find it nothing wrong with insisting that, okay, well, here's what we agree the event's going to cost, $100,000. We will pay you deposits and then a week before pay you the rest to make up for that $100,000. But if there's additional expenses after the meet that it happen on site, I would expect that my client will get an invoice and 15 days to pay it after they get the written invoice, because otherwise the money's out of your account, and what if you want to challenge it? Because there were some added costs you didn't agree to.
And then getting that money back from that.
Good luck.
Yeah.
Not impossible, but you're going to see me for that probably.
Jenny posted on here, seeing hotels add service charge tax if you simply want to get bottled water for a presenter. Yeah. I need one bottle of water.
Yes. Good comment. I do have to say, though, that I say this understanding that many venues charge a lot of money for that bottle of water. It may not be free. But on the other hand, there is service involved. It's like my family, we had a family friend of my parents who was a multi-millionaire, but would go to restaurants with his own tea bag and just ask for hot water. And then he would get angry if they charged him $3 for the hot water. And because he brought his own tea bag and it's just water. And they would say, you're paying for the service. If you don't want service, go to nothing against McDonald's, but they would say, go to a fast food chain. So understand with the comment about the service added, again, it's what you negotiate, but I do think you should understand that service is often provided.
Right. We're not in there serving the food ourselves. We're paying the people, the individuals there who are carrying those trays across the room to get to our attendees, et cetera. So there is that cost added to that. And I know I sent you something before when we were deciding to do this webinar about the cost of coffee, which is probably a whole nother conversation, but somebody was being charged $257 plus inclusive for 1 gallon of coffee. I mean, that, I don't know. That seems ridiculous.
Yes. But again, unfortunately, there are certain elements that are profit centers. And they are because people customarily pay it. I suspect that if everybody who plans meetings got together and said, we're not going to pay $200 for a gallon of coffee, and I hope it's not always that much, but if they would say that, then the market would dictate the price goes down. But the fact is, very few people focus on the cost of coffee when they book a meeting, and they only find out about what it is later. And then they can't negotiate because they're at that property and they're going to have to, their attendees need the coffee. It's almost in a way, why does a hotel close to Disney or some other famous attraction charge more? Because people insist on going regardless of what they charge.
Right. Exactly.
I don't need to pick on Disney. It was just an example.
Oh, all right. So somebody, let's see, when you add sales tax and service charge. Oh, actually, she said major hotel brand is charging $175 plus per gallon of coffee, and then $14 and change for an 8-ounce mug. They're charging you for the extra mug? That I don't get.
Well,
yeah.
Look, this is a free country, or if you're in Canada, Canada's free too. I would say you need, now that you're aware of these issues, this is a question you should ask before you sign the contract, and then add the cost of coffee and other amenities into the mix and decide if it's right for you. Again, I suspect that if you go to some place that needs your business, because it's not a first tier, it's not Las Vegas or New York or another first tier town where maybe they're hungrier for your business, they might be more flexible about these things. I frequently see catering, particularly for staff, added to in the concessions in contracts.
What do you mean by that?
Well, so a group that as part of the deal, the hotel will agree to provide coffee and refreshments for this in the staff office,
Gotcha.
Complimentary during the meeting. That's what I mean. And maybe they would do it on a wider if it's a matter of keeping your business.
Right. Yeah, and I often negotiate that myself. Is like staff meals are free, and I try to keep it the same exact meal as what's being served elsewhere. Yes. Oh, so she just clarified it's how much you divide the gallon of coffee by 16 cups, so it's $8 a cup of coffee, which is like going to Starbucks. Probably more expensive than going to Starbucks. Yeah.
Hopefully, it's good coffee.
Right, exactly. So Joan has 2 comments in here that I want to bring up. First one is that expectations are high based on much on the owners or as brand or management company too. And I think that's really important to talk about. And I've learned it from you and Tyra and Joan is like, you need to make sure that at the top of that contract, whose name should be added besides yours? The brand name, the owner's name, the management company's name, who should be at the top and who's then responsible?
Well, there's differing viewpoints on this. I know that Joan wants the owner's name on there, and she's right. That's frequently important. On the other hand, I often know that brands have standards, and that if you want to be a Hilton or a Marriott full service, they have to provide a certain level of service, or even more, a JW Marriott, a Grand Hyatt, a Ritz-Carlton, a Four Seasons, a St. Regis. There's certain standards they have to do. So I'm less concerned maybe about who the owner is in that situation. Although I do have a change in flag clause in my contracts that says that if the property changes flag, meaning brand, or in some cases, if it changes owners, that the group, just summarize, the group has an opportunity to ask questions, and that if they're not comfortable, they can cancel without liability and treat it as a cancellation by the hotel. Because meaning the group would hopefully have adequate remedies and not just you get your deposits back and you walk away, because that's hardly a remedy for many groups. But that should be in there if it's important to you. Now, if the most important thing is that we have to have a hotel that is adjacent or connected to the convention center, then it's of much less concern to you who the owner is, because you need a hotel connected to the convention center. So maybe you might not need the clause in that circumstance. But yes, I can't disagree with anyone who wants a clause about putting the owner's name in, the brand name, and then having a change in brand or owner clause.
Yeah, good point. She did get sued for whatever reason. I don't know what it is, but so making sure that it's there. But the other comment that she put in here was that RFPs need to be far more robust than they are. And I agree with that, but I also understand the fact that when we're using certain systems, the RFP lists it's like longing, looking at these things. But I think the RFP needs to be clear on what kind of practices that your expectations are and that what you want from them. And if they don't meet it, then don't even talk to them. Yeah.
So here's the thing. Automation has made some of us a little lazy in this process. And understand that the market has as well. When you do an online RFP through one of the companies that does online RFPs, they're making money when they hook you up with a property. So they're interested in how many rooms do you need, how many meal functions do you need, how much meeting space do you need, what are the dates, what's your budget? That's what they care about. They don't care particularly about how many special meetings do you need. Do you need to ensure that a certain number of restrooms are gender neutral? Are they interested particularly in particular accessibility issues that you might have? If you may be a group that still has COVID protocols of one way or another, they're not going to ask about that in an online RFP. But that doesn't mean that each of us as a planner can't still take advantage and attach those additional conditions to the online RFP or send them some other way. It's really on us. If you're a planner, it's on us to not insist on those provisions, even if it's not on the convenient online form, because you should be asking about all those things if they're important to you. And I can tell you, I deal with this world. I'm seeing now sustainability requirements, in addition to the things we've talked about, DEI requirements, purchasing from minority vendors, from other kinds of DEI businesses. But you need to make an effort to get those in the RFPs.
I wholeheartedly agree. And that goes with any kind of food and beverage standards that you want. If you want to bring in sponsors that are food and beverage properties, that should be in your RFPs. What are your positions on this? What is your corkage fee if I'm bringing in a wine? Or because I know a vendor who was coming to an event in New York, and they were going to get their product to pour, and the fees that the hotel was charging were astronomical. They ended up just sending their canned product instead. And it's contracts that those hotels have with certain distributors and certain food service companies to get that product in there. So I love the fact that you're saying that these things need to be added into the RFP so that you understand them. Yeah.
Yes, where property isn't willing to meet your requirements, then you know earlier that they're not appropriate for you, for your group.
Right, exactly. And because then it's just like, okay, well, you don't have enough rooms to meet my thing, so I'm not going to talk to you. So if you can't do this, then I'm not going to talk to you either, right?
Yeah.
Unless you're willing to go, same kind of thing.
Yes.
Redesigning the RFP thoughts for future on all these issues. Our planners must insist on getting answers. Yeah, because it is. You find out at the last minute, hey, you're not going to do this, and what are you going to tell your client, right? Oh, sorry, I didn't realize it.
Yeah, you could be out of luck. I'm not going to say you are out of luck, but you could be. And again, I'm finding this particularly with groups that have goals on food donation, sustainability, gender neutral restrooms is something lately I'm seeing more and more.
Really?
And some venues do it, some don't. But if your attendees have an expectation that there will be gender neutral restrooms and important to them, you're kind of caught if you didn't ask them any questions.
All right, Josh, we're at 1 hour, but I have two questions left if that's okay.
Sure.
One is that the Food Donation Improvement Act was approved by Congress and the Senate and going to the White House for approval, which improves on the Bill Emerson Good Samaritan Act to make it easier for food donations. And I'm working to get somebody on the show to talk about that specifically. But how can we, in our contracts, put that going forward to make it, have our properties say, oh no, don't make me do this, right? Which they do say that at the last minute. Do you have any history with that?
Yes. Well, first of all, you have to ask during the RFP stages if it's important to you. The challenge here isn't that most properties, they're happy to donate. I mean, as long as the food is in condition, it can be sent. And the law protects you if the food is in good condition when you send it. But the challenge that may not be apparent is the insurance companies. There are insurance companies that have told these caterers and these hotels that it may be legal, but we don't want you donating because it's a liability. It's a potential liability. If someone gets sick, you're going to get sued. And it's a nice thing to do, but we don't want you to do it because we don't want you to take the risk. And that's really, to me, that's the issue we have to deal with, because I think that was an issue with the current law. And even though liability is often dealt with in these federal bills and the bills that states have, but going back to your question, I think you got to mention it up front that it's important to us that our food be donated if we don't eat it.
Right. All right. So the final question I have, which is what I ask everybody, in your lawyer world or your perspective in general, what does a safe, sustainable, and inclusive food and beverage experience mean to you?
Well, it means that you put all of your needs in the contract that will ensure having the attendees come, they eat, they drink, you pay, everybody goes away happy, nobody gets sick, and nobody pays more than they agreed to pay or expected to pay. In my lawyer world, that's what it is. Everybody knows what they're getting into, performance is as expected, and people go away happy.
That's awesome. And I think that's just as important as what's on the plate. Yeah.
Yes. And the legal plate too, yes.
Right. Yes, exactly. Thank you so much, everybody. I really appreciate Josh. You're a wealth of knowledge, and everybody, you can reach Josh on LinkedIn at Joshua Grimes. Find him there or use that link there, long term there. But you are a breath of industry knowledge, and I appreciate it. I love it. And I'm so glad that you help protect planners out there. And not that we're up against hoteliers, but we do need to make sure that we got a good contract.
These are the people we have to dance with, and we need to make it work for everybody. But thank you, Tracy. I've enjoyed today. I've also learned from you in the past, and I appreciate the opportunity to talk with you and to those who are watching.
Yeah. We had 15 people watching at one time, so live, which is great. So everybody, thank you for being here. So join us next week. And until then, stay safe and eat well. Thanks, everyone.
Thanks for listening to the Eating at a Meeting podcast, where every meal matters. I'm Tracy Stuckrath, your food and beverage inclusion expert. Call me and let's get started right now on creating safe and inclusive food and beverage experiences for your customers, your employees, and your communities. Share the podcast with your friends and colleagues at our Eating at a Meeting Facebook page and on all podcast platforms. To learn more about me and receive valuable information, go to tracystuckrath.com. And if you'd like more information on how to feed engagement, nourish inclusion, and bolster your bottom line, then visit eatingatameeting.com.